I have started the recording. Yeah.
Deepak ji? Yes, please start the recording, Deepak ji. Okay.
Usually you're on mute.
Sorry. Can you now? Om Sahana Vavatu Sahano Bhunaktu Sahaviryam Karavavahi Tejasvinabadhitamastu ma vidvishavahi. Om Shanti Shanti Shanti. Pranam to all the participants to our third day of IKS TKDL workshop in traditional knowledge, intellectual property and people's rights. Today, Madam Asthana Madam, Dr. Lakshmi Asthana Madam is here with us. Madam will take the session on how we can protect our traditional knowledge. Madam has doctorate in chemistry from Bhava Research Atomic Center, Mumbai. So, Madam has more than 20 years experience in TK and how we can protect our IKs and TK with two different aspects. One is defensive, another is positive. So we will listen from Ma'am. So, Ma'am, pranam, and please start your session. We'll listen.
Thank you, Piyush ji. So I'll just start my presentation, share it.
Yes.
I have, is the presentation visible?
Yes, visible.
It's in slide mode?
Yes.
Okay, thank you. So pranam to all, a very good afternoon. So I know you have been already listening to other experts on this topic. So you have had 2 days of sessions already gone. Today, I will talk about protection of traditional knowledge, defensive and positive. In this context, I will talk about the role that traditional knowledge digital library plays in the defensive protection, give you more information about how and what we do in the traditional knowledge digital library. So let me begin. Some basics you already know, but it's more like to just remind you where we come from and where we are going to go through in this lecture. So while traditional knowledge is understood by all, we all know what is traditional knowledge or Indian knowledge systems, IKS. But in the international context or in the global context, there are discussions on traditional knowledge because in the international in different nations, the understanding of traditional knowledge is different. This is just to give you an idea of how things move at the global level so that when we come to the national context, we also understand it in a wider way in the importance of traditional knowledge in general. Okay. So the World Intellectual Property Organization has a working definition of traditional knowledge, though it is not an accepted definition. It says that it is knowledge, know-how, skills, practices that are developed, sustained, and passed on from generation to generation within a community, often forming a part of its cultural or spiritual identity. So we do understand the cultural and spiritual identity part, and that traditional knowledge is not a single dimensional aspect. It has several aspects, and all these things have to be treated holistically to understand the traditional knowledge or the IKS in its totality. Okay? So what are the kind of traditional knowledge that we are talking about today, and what are the sources? In order to understand how to protect them, we'll have to understand what they actually are. Okay. So the traditional knowledge in the context of today's talk that we will be discussing is all the intellectual and intangible culture. It also includes the intangible cultural heritage. Okay. You may have heard of terms like traditional cultural expressions along with traditional knowledge. You might have already also heard of intangible cultural heritage. These are all in the wider context. These terminologies also come into play. They are not exactly the same, but in the if you look at in the broader sense, there could be aspects which are overlapping. Okay, so basically we are talking about practices, knowledge systems of traditional communities, including indigenous and local communities. Basically, in India, for us, it is not only the tribal population; it is all of us. Basically, we all have a local cultural background through which we also all of us have some imbibe some traditional knowledge into our life, although in the tribal population this is much more pronounced and they may be using it in a much bigger way than we do in the urban you know urban as the urban population uses. Okay, so in the context it can be agricultural knowledge, it can be scientific technical knowledge, ecological knowledge, medicine knowledge, biodiversity related information, especially in today's context of climate change and so many other things that are happening, evolution changes that are happening, maybe in the sense that we are not as nature friendly as before. A lot of this information, if applicable today or if it can be integrated into the current understanding of science and technology, it would be very useful. Okay. So in terms of sources, it could be in textual form, that is in the form of ancient texts, manuscripts, in journal, articles, books, etc. These will be secondary sources which I will be discussing. And primary sources will be individuals, communities, families. They are all knowledge holders and traditional knowledge contributors in general. Okay. So in case of text, I have marked here languages and accessibility. We all know we have a lot of manuscripts in India. Okay. We have documented over 50 lakh manuscripts, that is through the National Mission for Manuscripts. They have conserved 9 crore folios of manuscripts. They have digitized 3.3 lakh manuscripts and published so many, But yet we have thousands of manuscripts which are lying in individual collections, in libraries, and not well maintained. Okay, so the problem with all this published information that we have and the need for why we need to protect them is that we are losing a lot of this information. Okay, not only in manuscripts, even in books. We know that all the kind of information that we have, for instance, in traditional knowledge, in a big way, we work on traditional medicine, that is the Indian systems of medicine like Ayurveda, Unani, Siddha. So many of these books are already out of copy, out of print actually. And the problem is you may get 1 or 2 copies somewhere in some library, very difficult to access and very difficult, to take prints or, even get copies of. So slowly we're losing all this information. If that one manuscript or one text is lost from that place, we lose this information forever. So there is a very dire and important need that we need to protect all this kind of traditional knowledge. In the undisclosed category where it is not in the form of print, I'll tell you more about it, maybe a little today, and maybe we'll discuss more about it tomorrow. They have even much more complex issues associated with them. At least when we talk about text and manuscripts, they're in some printed form, in some fixed form that we know are currently there, or perhaps not in very good condition, but still to a large extent, when available, retrievable. Okay, but it is not the same case in oral traditional knowledge or undisclosed traditional knowledge. We'll discuss about that. Then we also have, we have knowledge in the form of text. We have knowledge in the form of oral traditional knowledge, which will be undisclosed knowledge. India is unique in this context. So if you look at traditional knowledge abroad in other countries, globally, a lot of their traditional knowledge will be the undisclosed kind. They do not have that kind of documentation which India has had. Okay, we always had this Guru Shishya Parampara. We also had this habit of chanting and all those things of repetition, due to which all this information got into memories and later on got transferred in the form of some written form, in form of inscriptions or in palm leaf manuscripts. It got transferred. So we have so much of information in India which is documented also. Okay, that's a unique case in India. But we also have a large tribal population, more than 10.4 crore people, indigenous, belonging to the different regions of India with very diverse knowledge. Okay, so if you move from Jammu and Kashmir to Kanyakumari and from Gujarat to the northeast, you will find there is a lot of information. There may be commonalities, but there is also a lot of diversity based on the geographical locations, based on the ingredients or the kind of biodiversity that is available in these places and the kind of challenges that they face due to the terrain or due to the geographical location. So based on all that, there is a lot of diverse information, and this is a part of their natural habitat, a part of their lifestyle. They have imbibed it and they practice it wholly, right? Okay. This kind of knowledge can be, related to agriculture, related to biodiversity, water scarcity, pollution, and so on. Okay. So it is maybe, probably in some printed form, but not available in printed form. But that printed form could also be within a very close community, okay, in a particular language that only a set of people understand, and so on and so forth. So having this in the background, that is, we have so many diverse, formats and content of traditional knowledge or traditional cultural expression. And India being such a, language-rich country or even script-rich country where all the languages are written in different formats or different languages are written in common scripts, and so many of those scripts dying now. Okay, so there are a lot of languages in India which are spoken by a very small group of people, and probably if that group disappears, the language also disappears. So these are very, very important, urgent needs for why traditional knowledge needs to be protected. Okay. So in the context, I have put on the slide a few of the things that we do have in India, and diverse topics such as even dairy production or methods of agriculture. A lot of information is there in metallurgy, materials, metalware, tool making, pottery, so many things. Okay, architecture. We have temples which are thousands of years old. Okay, which probably it is difficult to imagine how they were constructed in those days without the modern technology or the modern amenities or the devices and tools that we have today. Okay, but yet they stand testimony to the historical evolution of the architecture, and also that in those days we could build such structure. Okay, so similarly we have folk art, artistic folklore, performing arts. There's so many folk forms of dances all over India. Okay, so you may have heard of so many. So I just put a few on the slide. So we have Bhavai from Gujarat, we have Lavani from Maharashtra. So you also have Kathakali, Kudiyattam, all these things from Kerala, so on and so forth. Okay. And non-performing arts, we have sculpture, we have painting, we have embroidery, weaving, carpet making, archery, so many things. Okay. So some of the examples are like, Pattachitra, Bandhani, the way of, designs on cloth or even on other things where Bandhani, the tie-dye kind of designs that people make. Then we have other things even from Ladakh. So we have a need to protect the traditional knowledge. Okay. What are the things that we need to keep in mind as we proceed in this talk is we need to remember certain things in the context of traditional knowledge. Why we are protecting traditional knowledge? Primary, most important objective is a lot of this information is being taken by other people, used for commercial benefit or used for any other reasons without anything going back to the community which has shared that information. Okay, so primarily we want to prevent misappropriation. The other thing is, the moment this information transfers to someone else, the spiritual and cultural identity is not taken for. You wouldn't even know where from this information came. For instance, there are designs which designers have taken and transferred to their maybe clothes or something, and probably no one even knows that there was an original community which had this kind of design, and and that this, the whole art belonged to them. Okay, then by losing this traditional knowledge, often the livelihood of knowledge holders also go. So in protecting traditional knowledge, we also need to protect livelihood of knowledge holders. It helps us in identifying the ownership of traditional knowledge and also ensuring that benefit sharing, attribution, or some sort of compensation goes back to the knowledge holder. And most importantly, whenever such information is shared, disseminated, it is necessary that the knowledge holder is aware of what he is sharing. So here he or she is sharing, that's a prior informed consent. More about this we will discuss in tomorrow's talk, because tomorrow's talk is more focused on the rights of these people. But this is to keep in mind that as we proceed, maybe some of these things will also come in today's talk. Okay? So when I am talking about misappropriation, we're talking about seeking of IP ownership, or in some way taking away the ownership from the original knowledge holders, okay, of some indigenous knowledge, of some information that was available with the community, originating from them, but taken away by somebody else for commercial benefit. Okay, so this is a kind of wrongful exploitation. It is, taking away without compensation. Here, the knowledge holder is not recognized, is not given any compensation, is in no way acknowledged that this information comes from that person. So in such a way, this is a wrongful exploitation and misappropriation of TK. So the protection of TK stems from this important need for preventing such kind of misappropriation of knowledge systems that are available all across India. So when I talk in the context of traditional knowledge digital library, the primary objective why we have created the traditional knowledge library, a digital library, was for preventing misappropriation and biopiracy. Three examples we always cite, although these are historical examples, they're very important in the context that these are such well-known examples. In the sense, they are so commonly used across India that we would never even think that somebody would take patents on them. For instance, the wound healing properties of turmeric, which all of us use day in and day out. We just, suppose there is a small cut in the finger, you just take a paste or the turmeric powder itself and apply on the wound. Then basmati rice, which is commonly known across India, and fungicidal properties of neem, in treating diseases in plants. All these were patented. So the problem is, even a more recent example like kilta, which is that wooden basket which they carry on the back to fill, agricultural produce. Even this was patented recently, although now it has been revoked by the High Court. The problem with having such patents or taking of such intellectual property is that when they are filed and when they are granted and when they are revoked, okay, there is a time gap, and it takes a lot of effort, money, resources, and such cases, because jurisdiction of patents, which you may have heard yesterday, are all geographical location specific. So if a patent is granted in US, the jurisdiction is US. So if you have to fight the case, you'll have to go to the US court. So all these are constraints while a patent is granted, and you have to get them revoked at the level of the particular national jurisdiction. So you can see from here that the Neem case took 11 years for revocation because they kept on appealing. So once it was granted, they appealed to the European, the board, which was the EPO board, which was there, EPAB. Then they went to the court, then they went to the higher courts, and by the time it got revoked, in the sense that this information is already known, it took a long time. Also, to present such information, it was difficult. It was difficult because we had in different languages, we had in different formats, which probably the patent offices did not agree upon. Okay. So the defensive protection that we are talking about, which is there in the title of this slide, of this talk, is stems from here. Okay. So what is defensive protection? When you talk about defensive protection, it is a set of strategies which is like a preventive thing. Okay. So it prevents others from taking in illegitimate or unfounded IP rights over traditional knowledge that belongs to someone else. So in this context, we are talking about traditional cultural expression, traditional knowledge, information related to genetic resources, so on and so forth. Okay? So we create a mechanism through which that exploitation illegally is prevented. Okay? So this is the negative right. You talk about positive protection, it will be a positive protection like you have for intellectual property rights, which you can go and contest, which you can go and fight for in a court of law, say, and that empowers the person and provides them some concrete rights which can be fought over. Okay, that is to protect and promote traditional knowledge. Okay, in the limited context, positive protection is there in some indirect manner, but there is no positive protection in the sense that, like the IP law that we have for patents, we have for copyright, we have for trademark, or the other intellectual property rights that you have heard of, no such protection is available for traditional knowledge per se in India. There are some other things which we'll talk about later so that you understand that how those can be indirectly used to protect, but directly as a positive protection for traditional knowledge, they do not exist in India. So there is a need to create not only national laws, but also international laws, a kind of sui generis system that is unique to the needs of the TK and traditional cultural expression knowledge holders, so that they have a path for redressal at the legal level, right? So examples of defensive protection. Traditional knowledge is the prime example which we'll be discussing today, but it is not the only example, okay? For instance, texts which have actually taken information from knowledge holders and published, they also are a form of defensive protection. So because they contain the information, and if you talk about existing knowledge or published knowledge, this information already exists, so nobody will be able to take a patent on them because it is prior art, right? So if you are not speaking, or if you, I mean, until the time that we come to the question answer session, maybe you all can keep yourself muted. Okay. Then we have other ministries also publishing information, like the Ministry of Tribal Affairs. You go to their website, you'll be able to see that there are books on different states in India, and a lot of associated information related to traditional knowledge, about the communities, and a lot of other information. So you also have these database of ethnomedicinal plants, which the ICMR along with their various institutes have published. Okay. Then there are several databases, but these databases are more like medicinal plant database. This is an NMPB, National Medicinal Plant Board database. They have a few quite a few of medicinal plants where they have talked about the vernacular names, their use in Siddha, but these are all very restricted, not very detailed descriptions, but there are list of plants here. Then you have other databases also, like the NVIS database on medicinal plants, which talks about, here also you have botanical names, you have vernacular names of plants, okay? And all these contain images, and probably some information related to constituents or chemical constituents also, so that you're able to identify the plant. Okay? So this is another example. All these will be presentations will be shared with you, so you can go and have a look at these databases, okay, for information. There are other databases. See, more when you talk about traditional knowledge today, a lot of us have the scientific bent of mind. So we think that traditional knowledge is unproven knowledge, unscientific knowledge. So why should we believe in them? Although it has been time tested in the sense, for if you talk about traditional medicine, it has been tested over generations and it has worked. But yet we feel that if it is not scientifically validated in the modern sense, then perhaps it is difficult for us to understand as to how this actually works. Okay, so more recently, a lot of people have been validating the traditional knowledge that is available in the text. Okay, so for instance, you would find this ICAR publication wherein you will find these validated Indian traditional knowledge which is there, which is cross-sectoral in different location zones, and they have done experiments for that and shown that the traditional knowledge actually works. Okay, so again, there are several examples of validated traditional knowledge too. Okay. So coming to the traditional knowledge digital library, which I'll focus on a bit. Okay, so you must have heard yesterday that traditional knowledge per se is not patentable in India. So an invention which is in effect is traditional knowledge, or which is an aggregation or duplication of known properties of traditionally known component or components, is not patentable. Okay? This comes under the section 3P, and it's under the section where the section 3, wherein it describes the inventions that are not patentable. Be it so may, this is also a defensive type of protection, okay, where you're preventing traditional knowledge per se from being patented. But this is territorial. Within India, we have this restriction. So when I talk about the traditional knowledge digital library, which is another important example of this TK protection, it's unique. This work started about 25 years ago. We are on the 25th year of our inception. It's a database of value-added traditional knowledge information, wherein we combine the ancient with the modern. Okay, so we are bringing these two closer. So we start with the ancient text, but end up with a report in which you have all the data or the information in modern terminology, so that a modern practitioner, like who has studied in the modern scientific schools, can understand. Okay? So we have information from Ayurveda, Unani, Siddha, Yoga. We have Sowa Rigpa. About 5.2 lakh formulations and techniques, that is practices, have been transcribed into this database. We use something called traditional knowledge resource classification. This is not a translation. We use select portions of the traditional knowledge text and transcribe only that information in a structured format, okay, which is easy for a patent examiner to understand as prior art as a prior art database. Okay, so it's available in 5 international languages. Access right now is provided only through non-disclosure agreement to 17 patent offices worldwide. Although we are looking at sharing this information with others, because we have got cabinet approval for doing the same, and it will be implemented soon, wherein through subscription you would be able to access the TKTL data. Okay. What we also do, in addition to collecting this information, transcribing the information, and creating the database. Can you please mute yourself? Yeah. Thank you. So we also request everyone.
Yes, ma'am, I am doing. I am checking. I am doing. Astu.
Thank you. So we also file third-party observations and pre-grant oppositions, which are national provisions and national patent laws, wherein we can present evidences of traditional knowledge. I'll just explain a little bit of it later. Okay. So the TKDL database, what we do is, this is the entry application, wherein we use an internally developed application to create the content. Okay. So we identify the information that we want to put in the database, enter it through codes. So all the terminologies can be converted into codes which are available and created by us. And through that, a report is formed, which will be easily understood by anyone else. For instance, we start with text like this. Okay. So in this corner is a Malayalam, Ayurveda Malayalam text. In this side, you have Hatratnavali, this is Sanskrit text. Then below it is a Sowa Rigpa text, which is in Boti language. Then this is a Siddha text in Tamil. This is a Urdu Unani text. Okay. So Urdu Unani texts, for instance, are available in Arabic, Urdu, and Persian. Ayurveda is written in so many different Indian languages. Majority of the older texts are in Sanskrit, but you will also find old texts in Malayalam, in other local regional Indian languages. Siddha is written in Tamil, and also there are Malayalam texts in that. Yoga, of course, we find texts in different languages, including some very local regional dialects also. So this information is varied and from different texts. But what it ends up as is in this form. Okay. All these texts we converted into a structured format. Okay, so structured format in the sense it has a title. So we explain how long the knowledge is known. Although there is a publication date, that publication will be a publication year, but based on when the author was, used to write, we know when this knowledge was available for the first time. So that knowledge known since. Then we write the details of the process, formulation of how these, particular medicines are prepared, what is the composition. Herein comes the value addition. Value addition, all these names are not botanical names in the text. They are old names or old descriptions. A lot of these plants are not even written in the form of names in the ancient text. They would be some sort of description indicating or implying that it is this plant. Okay, so a practitioner or a person who is well versed with the system of medicine would be the person who would be able to interpret that information. So all of our project staff who work on these are usually the practitioners of that particular system of medicine. They are doctors, of Ayurveda, Unani, Siddha, and so forth. Then you have therapeutic compositions, how they are prepared and how their dose is given, what is the mode of administration, and whatever information that is there in the text. Because as a prior art, only the information that is available in the text is shared. Okay? And finally, the most important thing is the data, that is the publication, prior art, that is the book in image which I showed you. That image will also be included. And where possible, we also include images of plants so that it can be easily identified. So TKDL as a database has several advantages over the other databases I showed you, where only medicinal plants were mentioned and probably one-line information about their traditional use. Traditional Knowledge Digital Library takes a very exhaustive explanation from the text and converts all the ancient terminologies into modern terminology. Then, since we cut across different systems of medicine, you will understand the commonalities and differences, which plants are used for what disease, in which system of medicine. All those things can be, understood from the single platform of TKDS. Okay? So you can see the value add and the enhancement here. Just from that one TKRC code, you will be able to know what it is called in Ayurveda, in Unani, what is the common name, what is the botanical name. This is for the ingredients. Here I have given plant name, but it could be for any ingredient such as mineral, material, metal, anything. Similarly, for disease names also. So they will not be described like headache or appendicitis in those, but from the description, from the system, we do understand what they are referring to, and that way the correlation is made, and the English descriptions or the modern descriptions are created in the TKDL database. So far we have, as I said, about 5.2 lakh formulations. We are not only doing therapeutic formulations now, we are also working on traditional diagnostics, devices, tools, practices. You may have all heard of Sushruta Samhita, which is a very ancient text which talks about surgery, okay, Ayurveda, surgery in Ayurveda. And it has extensive explanation about the tools, methods, and so on and so forth. So all these things like Panchakarma, therapies, all those things are also now being included in the TKDL. We are also looking at agricultural practices and tools and traditional metallurgy also for inclusion in the TKDL. This is an over and above the 5.2 lakh formulations and practices which I have shown as the table here. Okay? And as I mentioned, we will soon allow access to the TKDL for other users besides patent examiners on a subscription basis. The other thing I spoke about is, where we actually identify patent applications which have traditional knowledge, compare it with the traditional knowledge information available in TKDL, present these as evidences to the patent examiner. So the patent examiner will then send it to the applicant and ask them how it is different from the invention that they have claimed in the patent application. So based on the evidences that we have sent in about 375 cases all over the globe, there is in select patent offices where we submit patent, these third-party observations. They have been refused, amended, withdrawn. All these based on the TKDL evidence. Okay. These are some examples that I have put. All these examples are also there on our website. Okay, so you can go have a look at our website and see how this mechanism works. That is third-party observation, and you may also, those who are interested and maybe have that kind of background and are interested in intellectual property, can actually go and look at the provisions in law and see how this mechanism works. Okay, so we actually contest the claim based on the information that we have. So we present evidences, and there are outcomes, like in this case, wherein the application was refused to grant. Okay. So this is similarly a case where this particular plant was used in three or four conditions, but we could find evidence for chronic diarrhea in the TKDL, and which we presented. And so the examiner rejected those very claims wherein the Tephrosia purpurea leaves were used for diarrhea. Okay. Now, TKDL is one such example where I told you that it's a very exhaustive example of traditional knowledge which is present in India, but of documented traditional knowledge. We still haven't gone into the information that is there in the oral realm, that is the non-disclosed traditional knowledge, but we are looking at those type of information also. We do have other databases. Everywhere I have mentioned the particular URL, so you can go and have a look. These databases are not really similar to the TKDL database because it is different in the sense that they have taken omics data, mostly modern data from journals and things like that, and then given the information. But you'd still be able to see that a lot of people are trying to collect this information and present the information. This is the Korean traditional knowledge portal. Again, much of the information is presented is from journals and modern articles. But they have correlated some terms, but not in a manner in which and in the in-depth fashion in which TKDL has done. The Philippine Traditional Knowledge Digital Library is actually based upon the TKDL because they came to us, understood how we worked, and have created a similar system for the information or the TK that is available in their country. Okay, so there are other such. Again, this is for information for you to go and have a look. Okay? We also have in India the National Biological Diversity Act, under which is governed by the National Biodiversity Authority, wherein they create something called as a People Biodiversity Register, wherein they go to the local communities at the village level and collect the information related to biodiversity, innovations, traditions, the local ecological knowledge and practices. And this is collected in the form of a text in the book. This is also not information that is publicly shared. A few of them may be available. But they are recently trying to convert it into the e-form, and this information will have restricted availability. Okay, so it will not be accessible to all, but it's a good way of collecting all the information that is there within the country. And in this way, we are again creating a defensive mechanism wherein the information is known to exist, maybe not publicly available, but still it will be possible for us to say this information is available in India. Okay, so defensive protection. Coming to the advantages and what are the concerns of such defensive protection. Advantages, now while discussing, we have already seen. The advantages are that it prevents erroneous grant of IPR and patents. It preserves valuable heritage. We are losing a lot of it. This will help us preserve them. We can identify knowledge holders. But there are concerns, okay? And serious concerns also. So what is it? Does such documentation make them more accessible and thereby trigger more misappropriation? Then while collecting such information, especially the undisclosed or oral traditional knowledge, was prior informed consent taken? When this is all, put in some form, in some fixed form, then what happens to information control? Who will be the owner? Who will be the custodian? So how will it be disseminated? Okay. Then extent of access. Should entire information be given, or we should maintain some of it confidential, just give excerpts so that people know that this knowledge exists, and in case they want to know more about it, then it should be, in between the knowledge holder and the person who wants to access. Okay, that's one way of looking at it. Then safeguarding the information. We have such technological advances now that, any kind of information can be hacked or lost. Okay, so while preserving such information in some through ICT technology, there needs to be very stringent safeguarding mechanisms. Also, ICT and technology advances are not restricted to this. For instance, when you talk about biodiversity or plants, the access need not be even physical. Okay, we have DNA and RNA digital sequencing information. So synthetic, materials can be prepared. They are not necessarily the biological, natural materials. So in such a case, would it be called misappropriation? And then how to prove it? And how will this be construed in the context of a court or somewhere, right? Then talking about positive protection. We spoke so much about the defensive protection. Positive protection is we don't have any exclusive law in the country that I already mentioned. But we have certain rights like patents, copyright, designs, plant variety protection, geographical indications. Can we use them for protecting traditional knowledge? There are challenges. Okay, what is the primary requirement in any intellectual property grant being given? It's novelty. Is your traditional knowledge novel? No, it's not novel. It may be dynamic. It's a living tradition. It may undergo evolution. There will be new elements. There will be old elements. But it cannot be classified as novel. Okay, so that's one thing, which is why it will never fit into the IP regime. Then they are often community owned, not individual owned, like you see in all these intellectual property rights where a person or a corporation or an entity owns the rights. Okay, here it is often community owned. You will not be able to delineate, and the problem will be that across states, like for instance in India, border states, this state, that state, a lot of people will be having similar knowledge or overlapping knowledge. So identifying the person, exact owner, who are the people, the community, all these are challenges in granting rights to such IPR. Okay. Then there are other Government of India frameworks that there are laws which can indirectly be used. For instance, you must have seen geographical indications yesterday. So the geographical indications is given for goods. It's given specifically for goods. But the problem will be there that the underlying traditional knowledge, though available and known, that is not protected. This is only for the particular item, the product. Okay. Industrial designs, okay, to some extent it can protect the designs, the weaving patterns, and maybe certain things, shapes, and certain art. Okay. But again, these have its limitations. One of the important limitations are all these are a particular term. Now, traditional knowledge is a living form. Okay. It is over the period of years. So the protection cannot be finite. The protection has to be infinite. And most of the IP protection that we have all have a specific term of protection, after which it will come into public domain. And that is not very acceptable to the traditional knowledge holders. Similarly, Copyright Act can be used for dance forms. It could be used for the poetry, art, the traditional, they have this way of singing songs or, rituals and all those things. Some creative forms can be protected through copyright. Again, specific term. Then plant varieties also can be protected because there are some old varieties which are, farmers varieties that act can be used. Then Biological Diversity Act is important in the context that there are norms of how access and benefit sharing should be done, and there are specific approvals that need to be taken from the the National Biological Authority, Biodiversity Authority, by means of which you cannot use this access such traditional knowledge without the approval of the NBA. Okay. And of course, we have the record of genetic resources and associated TK in the PDR. Similarly, the Forest Rights Act also has some provisions because it protects the tribes themselves to protect, regenerate, and manage forest resource, and also their right to stay there and their right to intellectual property and traditional knowledge, which relates to the biodiversity which is present in the place where they stay. Okay. Although we do not have, this traditional knowledge protection regime, you may go and have a look at some other countries which have national regimes. Okay. For instance, there is a Peruvian law. It recognizes the rights of indigenous people and communities to manage collective knowledge. It is, given in the form of an intellectual property right. So it has infringement action in case there is violation, like you have in the case of intellectual property rights. So if anybody violates the right of the indigenous people, they can go to court and they can have infringement costs, which can be contested. Okay? They also have registries of collective knowledge. Similarly, if you look at Africa, a lot of national legislation is available. Different countries have different legislation, but there is a common protocol, which is there in the ARIPO, that is the African Regional Body. Here, protection is available to TK and TCE, and the right holders have the exclusive right of recognition, right of authorization, right to prevent use without consent, receive fair and equitable benefits, and also, if you see, the most important thing is to institute legal proceedings against infringement and unlawful exploitation. This is the important thing. This is what we are striving towards. We have defensive protection, but no positive protection. And without positive protection, a lot of things will not happen. Okay. Defensive protection will be only to a certain extent. It's a complementary protection. But unless there is positive protection, there will always be difficulties for knowledge holders to protect their rights. A lot of work has been going on in the international level also to create an international regime. Nothing has happened so far. We've had 25 years of negotiations that is going on. So far, all that they have achieved is a treaty on protection of genetic resources, which is not much to say for traditional knowledge. But yeah, there is still hope for this because the TK and TCEs are still under discussion. Here, what will happen is the protection will be addressed beyond the national boundaries. Okay, so you will have in the prevention of misappropriation, misuse. There will be some minimum standards of protection. Okay, allowing the empowerment of communities, promotion of traditional knowledge, and control to access and commercial exploitation without the consent of the knowledge holder. Okay. Of course, in all these things, we talk about even IP regime. If you think what information is known should be used for the betterment of the welfare of people at a later stage. So the same holds for TK also. It can be used for enhancing research and development, but mindful of being the rights and livelihoods of the knowledge holder. Okay. So these are the things that I wanted to tell you about. And about the international regime, you can go to the WIPO site and have a look. There is ongoing discussion in the Intergovernmental Committee on Genetic Resources, Traditional Knowledge, which will give you a fair idea of what is the information that is there in this area. Thank you, Chair, so much for a patient listening. I'll stop here. Thank you. I'll stop sharing.
Bahu dhanyavadah, ma'am. So thank you for giving this insightful session. So let us complete our small assessment. Then we'll come back to question and answer session. Is it okay, ma'am?
Absolutely.
Yes. So we are sharing the link in the chat box as well as the Google Drive. Please complete the assessment within 10 minutes. Then we'll come back to Q&A session. Here.
Namaste, Piyush ji.
Yes.
Sir, actually, yesterday's session, due to network issue, the second half of the session I could not able to listen properly, and which is not yet uploaded in the drive, sir. Can you please look into it?
Which one?
Yesterday's session on
Session,
IP intellectual property.
No, you are talking about the assessment link or recording or PPT?
No, video recording or any PPT, sir.
Video recording is uploaded. Please check your Google Drive.
No, sir, in the drive I could not able to find that.
Okay, let me check once. And
Yes.
assessment link, the time is over.
Yeah.
So
assessment. No, sir. Assessment I have completed, sir.
Yes.
But some
so
15,
recording
20
I will
minutes
check.
I
I'll
could
check.
not able to listen the lecturer properly, so that.
Yes, I'll check the recording once again. Astu.
Yes. Yes, sir. Thank you.
Thank you. Not sir yet. Is the assessment link visible on PPT? Can anyone
Yes, sir.
confirm?
Yes, sir.
Yes.
Yes, sir.
You can also write.
Yes,
Huh?
sir.
Okay.
Yes, sir.
Thank you.
Yes.
Chalo to.
It is. Sir, I have a query. Just sir, I have a query.
Please give me another 5 minutes to complete, then we'll start. Huh?
देखो कब तक रहती है जेठानी हमारी।
रहेगी वो तो घुस गई तो
पता है आपको
पूरी फैमिली अवेलेबल।
उसे खाए हैं
अरे यार क्या ये
लड़की को बिरयानी खिलाई है।
क्या लेडी है
आज
बताओ।
तो कह रही थी शिवानी कह रही कि आज तो वो अपनी लड़की को भी गाली देती।
You have another 2 minutes, then we will start.
ये assessment link show.
Okay, so let's start. So we can take some of the questions. So we request all the participants,
Sure.
please raise your digital hand. We'll unmute one by one. That's the one. And if you have any written questions, you can also type there. We'll take. Mastu. Deepak ji.
Yes, sir.
Yes. Please proceed.
Hello.
Yes, you are audible.
Good evening, ma'am. Myself, Deepak, and I am from Bihar. And I want to ask if someone want to patent some kind of food which is helpful for people, then what is the process of patent?
If you can just explain a little bit, Deepakji, food in the sense, is it
Food is
available, known, traditional knowledge, what is
it's
it?
a homemade, ma'am. It's a homemade things, not food. It's like a chawanprash. It's
Okay.
kind of.
So I already explained to you, Apiyushi, maybe you can stop sharing your screen. Do you want to continue sharing? Yeah. So the thing is, if it is a kind of information that is already known and available, okay, so that is sort of a prior art. So that cannot be patented. Okay. See, there are two things you will have to consider for any kind of patent. The thing is, you must have heard of the three things that it needs to fulfill in order for any invention or anything, any patent application, the content to be a patentable subject matter. It has to be novel, it has to be inventive, it should have some kind of application. So if it is not novel, then it is not patentable. Okay. The other thing is if it is some form of traditional knowledge that is already being used over generations and it qualifies under the term traditional knowledge as defined there or as explained in the Patent Act, and again that would not be patentable subject matter. Okay, but in case there is some kind of intervention which you have done and in sort of modified or improved or done something which enhances the quality of the product, enhances, makes it better, or sort of increases shelf life, increases its economic value, then those kind of considerations are there by when you can actually patent that particular invention. Okay,
Okay,
food as
ma'am.
such is patentable subject. Yeah.
Ma'am, I'm asking process क्या है इसका? What is the process?
Process for patent. Okay, process is you will have to go to the most of the things are online now in the patent office. Are you aware? Have you gone and seen the patent office site? So there you will have the application. You will have to prepare a specification. You can have a provisional specification. You can have a complete specification. A provisional specification will help you to set your priority date. That is, if you want to fix that. A complete specification should have all the information that is related to your product or your food that you're what you're calling it. It should have claim. The claim is the subject, the protectable subject matter in a patent. It has to be submitted to the patent office. It will go into examination after it is published in 18 months. Once it is examined, they will send an examination report to you. You will have to answer any queries that the examiner may have. If he is satisfied, they will, give you a
Okay,
patent,
okay.
or if not, it will again go into other processes. Okay. All the procedures in patent office are expeditable. So in case you want it to be expedited publication, or you want to have expedited examination, then you will have to pay special fees and apply for it separately. All right.
Okay, ma'am. Thank you so much.
Amit ji.
Very good evening, ma'am, and all the speakers. So I have a query. Do patents grant access to study of Ruafza you have seen, the formula for creating the Ruafza? So is there any like right to practice?
You'll have to repeat. I lost you for a little in between. Couldn't hear a few things that you said. You're asking whether formula for patent for RUAFSA can be patented. Is that what
No,
you're
no,
asking?
no. Do patents grant a right to practice? In the case study of Ruafza, the formula for that other peoples also can use as list and all the procedures list, but in other cases of like the liquid ones, how they can practice, and do patents practice?
See, right to practice, I don't know what you mean. Right to practice simply means the right to use, okay? Or right to this. Now, in case of something, see, RUAFSA, as I understand, or any company proprietary thing, if they have some sort of, it's probably a proprietary formulation. Okay, it may be known to others, it may not be known to others. And if they have, it is a patentable subject matter. I mean, RUAFSA is a very broad example that you're saying. I'm taking any example for that instance, which is under a patentable term, then there is no right to practice. No one else can practice because it is actually under the, somebody owns the rights to practice it, okay? And prevents, the right is actually to prevent the other person from using it or manufacturing it, or for that matter, whatever. Sorry. If you talk about trade secrets and things like that, where there are certain formula which certain industries use, I'm not sure whether as a common person, you even know that formula. Okay, so I'm not sure exactly what you're talking about, because Ruafza is a very old product. Okay, so as
I'm
far as I
asking like,
understand, it's a formula which they have an in-house formula for preparing the.
so they can also patent the formula also, no? In that
You can
case.
patent. You can patent as long as it does not have ages. It is not known prior. Okay. So there should be no prior art. It should be novel primarily, and it should have an inventive step. Okay? Then you can
Done.
pick.
Thank you so much.
Yes. Then Nimya ji. Anirudh ji.
Namaste, ma'am. My name is
Yes.
Vardhini. My 12-year-old son has created a board game getting inspired from a mathematical sutra. And he has also composed his own sutras in Sanskritam for his game. How do we protect this game, ma'am?
Okay. So this is completely innovative, as I understand, correct?
Yes.
Yeah. So see, first of all, you will have to look. Since I don't know the details of the invention, so if you look at this section 3, it should not fall under any of those categories which says that it is non-patentable subject matter. As I understand, it is not. Okay, but there could be some things which you'll clearly understand when you know the boundaries of your invention. So games in general, I have not seen too many applications where games, but I have seen things like calendars, different ways of, almanacs, things like this do come for patents, okay? And probably they are patentable subject matter provided they fulfill all those, requirements of a patent application. So if you have this, the method of playing the game or some such thing, maybe the claims would have to be crafted in that manner. But I'm not sure about the
He has
sutras and things like
written
that.
his
That
own
may not be patentable subject
rules.
matter. Yeah.
In the form of rules, he has composed few sutras where it
Mm.
covers how to play and how to navigate the game and
Yeah.
how all the rules. Yeah.
The sutras themselves, like in terms of the language or in terms of the things, that will not be patentable subject matter, because patentable subject matter is basically for some kind of process or the product itself. Okay. So only those kind of concrete things will be patentable subject matter. It is a technical subject matter. So in those cases, maybe you would have to look at other things like copyright or something to protect that. But in general, the methodology and if as long as it is not any kind of algorithm or some such thing, probably it will be patentable subject matter. But of course, you'll have to construct the claims accordingly. Yeah.
Is it okay to present it in any conference before applying for patent?
My advice would be to not do it because although you do have grace period and all, but the best thing would be to give you apply for a provisional patent, because then the priority date will get set. Afterwards, you can present in the conference because your date will come before that. There is some time limit, some grace time that is given, but that becomes very tricky when you're not able to apply within the time limit. So it would be better if you apply for a provisional specification, in which case you don't have to give all the details. So there are some lesser number of things that you'll have to give. You need not give tables, you need not give the full details of method of doing the invention and things like that. You can provide the scope and put in a provisional specification. Scope cannot change in the complete specification, okay? So all the full scope should be present in your provisional specification, but some details can be missing, okay? So it will give you 12 months time. So in the meantime, if you want to make any presentations and things like that, you can, but avoid too many details which you will be putting in your patent application later on.
Okay, ma'am. Thank you so much.
Thank you.
Sumita ji, Dr. Sumita Jain.
Yes, sir. Good evening, ma'am. A very nice initiative from you people. I am professor in Government Ayurved College, and I have won 2 patents already. But I have some doubt, ma'am. Actually, I have 2 questions. My PG student is working on one formulation which is mentioned in Charak Samhita, and we have developed the process, because permutation and combination of the ingredients we have to change a lot many times, and then we have reached to final product. और उसमें दिया है श्लोक में कंठ्य means which is good for your throat.
Okay. Is she still speaking?
No, I think we lost you.
Hello.
Sumita ji, could you please repeat your last 2-3 sentences?
Yes, sir. Yes, sir. तो कंठ्य is word mentioned, और हमने म्यूजिशियंस इन द सेंस सिंगर्स और टीचिंग प्रोफेशनल्स पे उस पर काम किया. नाउ वी हैव टू टेक पेटेंट ऑन दैट टैबलेट. तो इज इट पॉसिबल मैम?
If it is a known, चरक संहिता में already वो प्रोडक्ट का जिक्र है, मतलब it is already known, चरक संहिता में the very same product is there.
Then you won't get, क्योंकि हम रेफरेंस पे ही हम काम करते हैं, पर चरक संहिता में एक सिर्फ श्लोक दिया है जिसमें कितना कंटेंट है वो नहीं दिया है, एग्जैक्ट फॉर्मुलेशन कैसे बनेगा वो नहीं दिया है.
वो सही है, लेकिन चरक संहिता से आपके बहुत सारे क्रिटिकल कमेंट्रीज हैं और बहुत सारे लोगों ने उस पर काम किया है. उसके बाद तो जब आप देखेंगे तो चरक संहिता के स्पेशली जो फॉर्मुलेशंस हैं वो सब उसके डिस्क्रिप्शन तो बहुत जगह है, और उससे यू कैन अराइव एट व्हाट यू आर टॉकिंग अबाउट. फॉर इंस्टेंस जो इन्वेंटिव स्टेप की हम बात करते हैं इन पेटेंट, ओके, वो यही चीज है दैट अ पर्सन स्किल्ड इन द आर्ट उस श्लोक को पढ़ के क्या वो सेम प्रोडक्ट पे आ सकता है. So if that is the case, again yours will be non-patentable subject matter, because Any person like you, why does doing permutations and combinations can arrive at the same solution? Okay, if that is the case, your invention will not have any inventive step. So it will not be patentable subject matter, especially in cases where you're talking about, just say, aap keh rahe ho ki it is from Charak Samhita itself. I doubt it is patentable subject matter unless you're doing something different. Yeah.
Actually, it is given for healthy people, and we have tried it in pathological conditions.
True. So it is more like a use case in the sense it's got a different use. But if you talk about uses in India, again, if you look at our patent law, a second use or a different use is not really patentable subject matter. Okay. So you will have to see whether you are somehow enhancing the bioequivalence, or you will have to present the case in such a manner. So if you're increasing bioequivalence, its bioavailability, or if you're enhancing it the way it reaches the particular organ, or its stability, such things
Yes,
will
yes,
be
I understand.
can be considered for patentability. Yeah.
Okay, okay. And another thing, ma'am, there is one procedure for panchakarma, and it takes too much time, and it is expensive. And we have worked on that process to make it easy and cheaper. So in that case, we should go for copyright or patent.
Then in what way have you done that? So I mean, if you without going to the confidentiality part of it,
नहीं
if you
मैम
can
कैसा है जो उसमें
copyright
ड्रग्स जो उसमें ड्रग्स यूज किए हैं उनका जो फाइनल प्रोसेस देना है पंचकर्मा की प्रोसेस के लिए वो बहुत ज्यादा टाइम कंज्यूमिंग है और उसमें क्वांटिटी भी 4 टाइम्स ज्यादा लग रही है उसको हमने चेंज किया और इफेक्ट देखा तो सिमिलर इफेक्ट दिख रहे हैं पर टाइम भी बच रहा है और पैसा भी बच रहा है
copyright, as I understand, is not for these things. Okay. So ये लेकिन patentable subject matter है क्या? That also I won't be able to say with the limited information I have. But copyrightable subject matter is copyrightable subject matter. No.
Okay. Because usually we do lot of things in Ayurveda college, lot many research work and even case studies or some clinical trials. But every time this happens, we published it in good journals. People use that all the things because you told that Aniruddha Varadarajan ma'am that don't disclose all the things in conferences and that I like the thing ma'am you told. So every time happens it like this only.
Yes.
Okay, thank you ma'am.
Thank you.
Astu ma'am. So we don't Nimya, last one we can take, otherwise we can. Astu ma'am. So pranam to all the participants. See you tomorrow. Madam will take the session, tomorrow's session also. That would be the ethical aspects, how we can handle TK ethically. So pranam ma'am. So let's close with Shanti mantra. Om. सर्वे भवन्तु सुखिनः सर्वे सन्तु निरामयाः सर्वे भद्राणि पश्यन्तु मा कश्चित् दुःखभाग् भवेत् ॐ शान्ति शान्ति शान्तिः मिलामः. See you tomorrow 3:30.
धन्यवाद.
Astu ma'am, pranamah. See you.
Sir, Piju sir, I was not able to give the assessment yesterday, sir.
So leave the assessment, please complete others. Okay, No problem.
Okay.
So
Okay.
keep the Google Drive link. Everything will be updated day by day. First,
Okay, sir.
chalo.
One more query, sir. Can I talk 1 minute? Hello.
Yes.
Yeah. I think on 15th of this coming December, I will be in the middle of my conference, so I won't be able to attain those the assessment. So can I submit it later? Probably. Is it possible?
No, please, because the slot is fixed. So please
Okay.
try to manage yourself. From yourself, please
Okay.
try to manage. Astu,
Okay.
chalo.
Thank you. धन्यवाद.
Pranamaha. See you.
It is compulsory to attend or optional?